Woke white people, I'd like to ask you a favor. Please stop asking for forgiveness for your white privilege. You're not fooling anybody. You're not helping black people or any other minority. And your public confessions don't make you look virtuous. They make you look disingenuous, which is a really nice way of saying fake, phony, and fraudulent. For starters, what is white privilege anyway? Because you're born with white skin, you have all these advantages that I don't have? Like what? Like you can get a mortgage loan that I can't get? I got a loan at a great rate, by the way, and I got the house. Why would a banker not give a loan to someone who met the loan requirements? He doesn't want to make money? I've never heard of such a banker. Or how about this? You can enter a store and not be looked upon with suspicion, but I, a black person, cannot, except that has never happened to me. But if I was a young dude with my pants hanging down to my butt, I could understand why the store owner would be concerned. I used to be a cop. Believe me, I understand. If I owned a store, I'd be tracking that kid too, whether he was black, white, or anything else. Or what if I had a store that had a history of being shoplifted by young black women and a young black woman with a bad attitude walked in? Would I be suspicious? Yeah, I would. Who wouldn't? I call that common sense, not bigotry. But there's another way of looking at this. In many ways, in today's America, blacks have more privilege than whites. It's been my experience that whites bend over backwards to give blacks every possible advantage. If two people are equally qualified for a job, the black person will usually get it. Big companies and prestigious universities fall all over one another trying to sign up talented black people. If you deny this, you are denying reality, which is what the person who dreamed up this whole thing did. A professor of women's studies at Wellesley College by the name of Peggy McIntosh. She wrote in an article in 1988 about all the white privilege she thought she had. She listed 46, including this one. I can choose bandages and flesh color and have them more or less match my skin. Wow, that's some kind of privilege. Soon others took up the cause. Today, these so-called progressives dominate our colleges and universities, imposing this absurd notion of white privilege on their students. That's too bad because it does nothing good for white students, and it does nothing good for black students. But of the two, ironically, the white students get the better of the deal. Let me explain. To acknowledge your white privilege is supposed to make you feel bad, only it doesn't. It makes you feel good because by acknowledging your white privilege, you're declaring yourself to be enlightened. And as a virtue bonus, it also makes you a better person than those whites who don't acknowledge their privilege. White privilege, which is supposed to make you feel bad, ends up making you feel good. Meanwhile, the real damage is to blacks. What makes whites feel good makes blacks angry. More than 50 years after the civil rights movement, the message is, you're still oppressed. How can this not create a victim mentality? And anyone of any color who sees himself as a victim gets angry. Now, I wouldn't deny for a second that there are privileges in life. They're all over the place. There's two-parent family privilege, that's huge. There's being lucky to be born in America privilege. There's good gene privilege. But white privilege, doesn't it depend on the person? Let's take this for example. A black lawyer and his wife have a baby, and a meth addict, single white woman has a baby. Which kid has privilege? The white one? Because he's white? Come on now. And here's the kicker. Even if it were true, all those claims about white privilege, so what? Would it change a single thing I did? If white people apologize for being white, is that supposed to help me? In what way? So let's be real. White privilege is an attempt by the left to divide Americans by race. It's all theory and all nonsense. If you want to fall for it, go ahead. It's a free country, but don't try to sell it to me. I'm an American who deal with my fellow Americans one-on-one. Try it. It works. I'm Brandon Tatum for Prager University.
Well, as noted earlier, People sometimes confuse civil rights with civil liberties. I think civil rights gets confused today with BLM. We'll try to clear that up. Civil rights gets confused with white privilege. But generally, in our context, what we're referring to when we do talk about civil rights, it refers to the rights of Americans to equal treatment under the law as provided by the Constitution and the 14th Amendment. Now, as you'll read about in this chapter number 5, there's been various groups trying to obtain a different kind of treatment under the law. And so what has happened is the law has adjusted itself to bring certain groups of individuals, whether they be defined by a certain ethnicity or religion, or whether they own property or not, or whether they practice a particular sexual activity or not, into the mainstream. Now, the book uses the word discrimination against various groups. So in this single short chapter, we're going to tackle that together. Now, an important thing that you've got to understand in understanding civil rights is the interpretation of the Equal Protection Clause. So we'll look at that as well. So overall, what we'll do is we'll go over the constitutional basis for civil rights and for laws prohibiting discrimination, so-called discrimination, and we'll discuss the reasons for something called the civil rights movement and the changes it caused in American politics and government. And then we'll look at the civil rights movements for women and some of the so-called obstacles to equality that women continue to face. And then we'll talk about specifically the pernicious government program known as affirmative action, which has been around for 65 or so years. Why has it been controversial? The gentleman who just spoke, he touched on it. We'll try to clear that up. But first of all, let's go into the discussion of the 14th Amendment. Then we'll cover the original Constitution, what it says about civil rights. And then we'll get into the specific portion of the 14th Amendment called the Equal Protection Clause. Now, simply defined, civil rights is a term that's defined as the rights of Americans to equal treatment under the law. We could probably leave it at that and go to chapter 6, but let's try to hash out the details as best we can. Now, there is mention of equal treatment under the law in an amendment that was passed in 1868 called the 14th Amendment. We'll break it down a little further. The 14th Amendment has various sections, 5 sections, and section 1 of the 14th Amendment talks about it. It says, no state shall deny to any person within its jurisdiction the equal protection of the laws. So that's a brief overview. Now, the original Constitution, the one written in 1787, signed in September and adopted by June of the following year in 1788 by 9 states, and by 1790 adopted by all 13 states. This Constitution, the one that's 242 years old, does not make any reference to equality. Surprised? Let me say that again. The Constitution, written by Madison and Wilson and the Pinckney brothers and all the delegates from the 13, well, actually from the 12 states, because Rhode Island did not send any representatives or delegates. This Constitution did not make any reference to equality. Now, there's reasons for that. The framers of the Constitution were more interested in natural rights, like those discussed in Chapter 1, the ones that John Locke talked about. Each and every one of us has a natural right. All humans, whatever the gradation of their skin color is, to life, liberty, property. Jefferson says life, liberty, and pursuit of happiness in the Declaration of Independence. So the Constitution was intended to protect those natural rights: property, liberty, your life. Now, to the extent where there's even a more specific equality mention, they do in Article 4, Section 2, say that no state shall deny persons the privileges and immunities of other persons coming into their state. That means that a person may travel to another state and enjoy the privilege of owning property, the privilege of seeking redress in the courts, the privilege of accessing the courts, the privilege of getting something like a will when you leave your property to your descendants. It can be enforced in a state using the courts. You can start a business in another state, or you can have multiple businesses in multiple states. So these are privileges, and you're immune from arbitrary treatment by other governments, other state governments. They have to treat your business the same as they do to a business started by a citizen of that state. So again, there's an implied equality. So let's go into the specifics. So the 14th Amendment comes around because of the end of the Civil War, and there are black codes passed by states controlling the activities of blacks and controlling their ability to do certain things, to access the courts. And so the people in Congress, the men in Congress, passed the 14th Amendment. And they specifically spell out, no state shall deny to any persons within a jurisdiction of a state the equal protection of the laws. In Section 5 of this amendment provides a legal basis for federal civil rights legislation. The Congress shall have power to enforce by appropriate legislation the provisions of this article. Now, most agree today everyone should have equality of opportunity, and states must treat all persons equally, and they may not discriminate unreasonably against a person. They've got to allow access to the courts and that kind of thing. Now, the Equal Protection Clause has been interpreted over the years, and especially in the last 80 years, by the United States Supreme Court, that all people must be treated equally and not discriminated against unreasonably. Now, the task of distinguishing what is reasonable, what is unreasonable, is difficult. Now, generally, the court balances the constitutional rights of individuals to equal protection against the government's interest in protecting the safety, the welfare, the morals of its citizens. And over time, the courts have developed three tests, three measures, three standards by which they determine whether the Equal Protection Clause has been violated. Now, these have been men and women on the Supreme Court who are fallible. They're not infallible. They make mistakes. They interpret it at one time different from what they interpret at another time. Some have been great students in their law schools, great lower court judges. Some haven't been so great. But over the years, what has developed is these legal tests to determine whether or not a law or an action or an activity by a government, like a state, by the United States government, by an agency of the United States government, by a local government, by a private institution, by a public institution of higher learning like a university, does it violate the rights of individuals? Now, the first test is the so-called strict scrutiny test. And this one has been around and used by the courts primarily within the last 75 years. The intermediate scrutiny has been around for 60 or so years, and the rational basis test is used constantly, even today. But let's start off with the strict scrutiny test. Now, the strict scrutiny standard is a standard used by the courts. And what the courts do is they look at a law passed by a state legislature or a city council or a school board or the United States Congress, or they look at some action by a federal agency or a state agency or a local government agency. It could be a parks department, a police department, it could be the Department of Commerce under the federal government. But they look at something that has happened after it has been brought to them by an individual or group of individuals. So the strict scrutiny standard will be used. It's necessary to promote a compelling state interest. if the law is proven to promote a compelling state interest, then it's okay, except that the law must be somehow narrow or focused to meet that state interest. That's what narrowly tailored means. So again, these are the standards used by the courts. This is the first one, to determine whether or not a law or action violates the Equal Protection Clause of the 14th Amendment. Now, if the courts sense that there's some kind of fundamental right, a basic right to life, liberty, property, the right to assemble, the right to protest, the right of practice one's faith, and so on, a fundamental right, they'll use this standard. And also, if there is a suspect classification, they use the strict scrutiny standard. Oftentimes, things like race, ethnicity, creed, religion, these would be what we call suspect classifications. They're classifications of people. They're based on certain, usually immutable characteristics, such as race. So laws based on those kinds of classifications, they're subject to this strict scrutiny. And oftentimes when the courts look at that, the judges, they interpret the laws, the actions, they look at the practical effects upon a particular race, ethnicity, creed, religion, or whatever classification, and then they determine, is this treating someone unfairly, unjustly, or is it discriminating unreasonably against a particular group? A key case in this was the NAACP versus the state of Alabama, where the Alabama state law said that all groups had to turn over membership rolls, addresses, names, phone numbers, everything about a particular person within a particular group. Their reason for this law was to ensure that they knew who was in their state. Well, the courts looked at the law, they looked at the practical effect, and they felt this was unreasonable because you could have, in their minds, and it was proved to them by the plaintiff, in this case the NAACP, the National Association for the Advancement of Colored People, they proved to the court that this was a way for the state to discriminate against blacks. They could intimidate blacks if they knew where they lived. They could place burning crosses on their lawns if necessary to prevent them from voting or moving about, those kinds of things. So they struck down this particular law as violating the 14th Amendment, the right of someone to fundamentally organize. We'll see this in chapter 6 when we talk about interest groups. You do have a fundamental right to assemble and organize and to peaceably protest. Now the next level was intermediate scrutiny, and this one is used to determine if laws based on gender are permissible. Now this is sometimes known as exacting standard, and the description of it, the definition of it is, it'll be used if a law is substantially related to the achievement of a governmental objective, an important governmental objective. Now, in the Michael case, the court, in the Supreme Court case, Michael M. versus Superior Court, they felt that yes, this was justified to punish young males um, for statutory rape, but not females, it has been ruled valid by the courts. The interest of the government was to prevent teenage pregnancy in those circumstances, and almost all the harmful consequences of teenage pregnancies fall on young females. Now, the next case, the Craig case, a law prohibiting the sale of beer to males under 21 and to females under 18 would not be valid, however. Now, the state of Oklahoma, in this case, represented by Bourne, proved that more traffic accidents happen by males between 18 and 21 who are under the influence as opposed to females. And the data shows it very clearly, but in a closer decision, I think it was 6-3 maybe, the courts were not convinced that this governmental objective couldn't be achieved another way. So they struck down the Oklahoma statute. So the state simply raised the age to 21 for males and females. There have been other laws that have been declared unconstitutional, like Orr versus Orr. This was a case between a couple, a male and female, and they used to have alimony laws which were leveled against husbands, but prevented husbands from receiving alimony from wives. This was a practice that had been used for, well, really thousands of years in human history, because the man worked, the woman stayed home, took care of the children. And so when there was a divorce, then the woman would continue to receive support. And even if she didn't have children, there would be some kind of remuneration to the wife, assuming, of course, she didn't have any job skills. So this was the case, Orr versus Orr, in which the court said, well, the woman now should not receive alimony. She's fully capable of finding a job and earning a living, and Orr should not have to pay money for her continued support. Now, in the Mississippi University for Women versus Hogan case, the courts declared that the policy of excluding males from this all-woman school was unconstitutional. That happened also in the United States versus Virginia case, where the Virginia Military Institute, an all-male institution, held out until 1996, when a state-financed institution was found to violate the Equal Protection Clause for not accepting female applicants. So the court said that Virginia didn't provide any sufficient justification for its gender-based classifications. The U.S. Military Academy in West Point up in New York along the Hudson River had already integrated voluntarily by 1988. Now, the last test I'll go over in this section is the rational basis test. And this is a test used by the courts to decide whether discriminatory laws violate the Equal Protection Clause. And I should say just laws. Now, the people that bring them say that they're discriminatory. Well, sometimes they're not. They're not discriminatory. For example, when a city regulates certain types of vehicles, like you cannot have your truck trailer in a residential neighborhood. That is a city ordinance. That's a legitimate interest in reducing traffic congestion in a particular neighborhood. We had big rigs along the streets in our neighborhoods. You couldn't back out of your driveway, or your children might be endangered, or the traffic itself by these big trucks would damage these roads, which are not designed or built to take the weight of these particular trucks. Emergency vehicles might have a greater problem of getting into these neighborhoods. So there are rational, there's reasonable justifications for passing these ordinances. So sometimes this is known as ordinary scrutiny. And there's only a few laws that make it to the Supreme Court that are found to be invalid. All right, so let's review. The Equal Protection Clause is found in the 14th Amendment. The original Constitution didn't have it. The original Constitution makes no reference to equality. It did provide protection of life, liberty, and property, and it mentions states must recognize other individuals from other states the right to own property, other individuals' privileges and immunities. But the 14th is added in 1868, originally, of course, to provide an avenue for the African-American males to access the courts. And that was what it was intended to do. Now, it's come to mean that states must treat people equally and they cannot discriminate unreasonably. And the courts have developed tests to determine if that has been violated. These three tests: scrutiny, strict scrutiny, intermediate scrutiny, and the rational basis test. And strict scrutiny is used by the courts when they sense there's a fundamental right being challenged or there's a suspect classification. Intermediate scrutiny is one used when there are gender-based laws used. Laws based on gender are permissible. However, they've got to be substantially related to the achievement of an important governmental objective. In the Michael case involving the differences in exposure to the bad effects of a rape, females are more susceptible to the negative effects than males. So we have to make sure that we do treat men and women differently based on gender. Now, in the Craig case involving sales of beer to men and women or young males and females, the court wasn't convinced that the state of Oklahoma could prevent males from getting liquor between the ages of 18 and 21, but allow females. They felt that that was an undue discriminatory law, even though the state had the evidence to show that the objective here is to lower the rate of accidents. And in the last two cases, these were in the late 70s, early 80s, and the court struck down the alimony law in Orr and the attending a women's university for a male law in the state of Mississippi. The last test is that rational basis, which is used for laws that are challenged, ordinances by cities, states, state statutes that are challenged, that somebody feels that this law violates my equality, it discriminates against me or this group of individuals. And oftentimes these laws pass the test and they are found to be valid. So with that, we'll conclude part one and pick it up with African Americans in our next session together. Thank you for your attention.